Breaking: I don't have N1bn to give Jonathan, Metuh tells court. Drama at Federal High Court in Abuja as Chief Olisa Metuh interjected in proceedings and overruled counsel over Goodluck Jonathan, the former president. Metuh is being prosecuted by the Economic and Financial Crimes Commission, EFCC, for alleged money laundering. He said he does not have N1bn to give Jonathan to appear as a witness in his ongoing trial. Chief Olisa Metuh, the former National Publicity Secretary of the People's Democratic Party, has urged the Federal High Court in Abuja not to set aside the court summons it issued to compel Goodluck Jonathan, the former president, to appear as a witness in his ongoing trial. Metuh, who is being prosecuted by the Economic and Financial Crimes Commission for alleged money laundering, challenged Jonathan's insistence that the defendant must deposit with the court, for and on behalf of himself, the sum of N1bn in line with provisions of Section 241(2) of the Administration of Criminal Justice Act, 2015, before he would mount the witness box. Jonathan, in a motion his lawyer, Chief Olisa, however, moved before the court on Wednesday, November 1, urged trial Justice N1bn to compel Metuh to pay the N1bn to cover traveling expenses for himself and his security personnel from his hometown, N1bn State, to Abuja. He said the evidence Metuh is seeking from him would amount to an invasion of his personal right to privacy and family life as provided for in Section 37 of the Constitution of the Federal Republic of Nigeria, 1999. He told the court that the evidence sought to be obtained from him was likely to expose him to a criminal charge, penalty or forfeiture. The former president further argued that the subpoena ad testifandum Justice N1bn issued against him on October 23 was vague, applied for and obtained on frivolous ground and in bad faith, saying it was meant to embarrass him as a person. Besides, Jonathan argued that Metuh was not a personal aide or his appointee and therefore could not have dealt with the president directly under any circumstance to warrant the invitation of the applicant to testify in the charge. However, the president said he was not doubtful of the fact that there was a contractual agreement between Metuh and the former National Security Advisor, Col. Olisa said, "The linchpin of this application is not that the former president is throwing doubts on transactions involving the defendants and Dasuki, but that he was not physically present when the transactions were going on, because he had many appointees. My lord, because of this, we are saying that he will not be a good witness to state what actually happened regarding the transactions. He can never be able to know details of transactions all his aides carried out within his over 4 years tenure in office. He is not saying that the transactions are fake or incorrect or fictitious, no. He is only saying that he does not know the details. Whatever evidence he will be giving based on the subpoena will amount to hearsay evidence." Nevertheless, in a 5-paragraph counter-affidavit that was moved by his lawyer, Emeka San, Metuh said he does not have N1bn to give Jonathan, who he said had in his own motion admitted that he, Metuh, served the nation well. Etiaba drew attention of the court to the fact that the bailiff earlier deposed an affidavit that he had yet to serve the subpoena on Jonathan. This application is therefore not only so speculative but premature and deserves to be struck out. With respect to demand for deposition of N1bn, the first defendant in his affidavit averred that he does not have such amount. "We believe that such demand is punitive and meant to frustrate the first defendant's attempt at obtaining an evidence that will assist him in the defense of the charge against him before this court." It is the view of the first defendant that from the first day that he was arrested, he made it clear that the release of the money was authorized by the former president and was released by the former NSA, Dasuki. My lord, this application simply seeks to set aside the subpoena and to save this nation the embarrassment of having a man who means a lot to the entire country as a former president, to step into the dock to give evidence. My lord, it is unprecedented, and the embarrassment could have been aborted if the charge against the first defendant was not preferred after he had disclosed to the EFCC the source of the fund for which the defendants are standing trial. My lord, in this circumstance, it is our position that this application be struck out, Ediaba added. Com had reported that Jonathan explained why he would not be testifying in the ongoing trial of Metuh. In an application filed by the former president before Justice Okonabang of the court, the former president said appearing as a witness in Metuh's trial would expose him to criminal trial.